Good afternoon, everyone, and welcome to the BHBA Immigration Section CLE on Ethics in Immigration Law. My name is Maggie Stewart. I'm the co-chair of the Immigration Section, along with Joanne Litt, who is here. And also you'll see Chung Bornbeck, who is an esteemed immigration attorney here in Los Angeles, and our presenter, Erin Joyce. We're going to be moving quite quickly along. We have a hard stop at 1 o'clock today, so we want to leave maximum time for Erin to present. I just will quickly say that if you are interested in participating in more of the immigration section events and planning, please join us this Friday at 12:30 for the immigration section executive committee meeting. Everyone is welcome. And next month in February, we will be hosting a CLE on immigration issues in family formation law. So that's immigration and surrogacy and adoption, which will be really interesting for people who are working in overlapping fields. So I'm going to turn it over to Joanne Litt to introduce Erin. One last thing, you'll be getting your CLE credit certificate emailed to you immediately following, and please use the Q&A for asking any questions that you may have as the presentation goes along. Have a great day.
Hi, everyone. I am proud to introduce Erin Joyce today. As a former 18-year State Bar Prosecutor, Erin is an expert in legal ethics. She has extensive experience in State Bar investigations and disciplinary proceedings, as well as 25 years of civil litigation experience. Prior to launching her firm, Erin served as the LA Fire Department as a chief special investigator, as a prosecutor for the State Bar, and as a lawyer in private practice. In addition to fighting for her clients, Erin contributes to the LA County Bar Association's Professional Responsibility and Ethics Committee and its small firm and sole practitioner section. Erin is on the faculty of Abraham Lincoln University, teaching advanced legal ethics, and on the California Lawyers Association Solo Section Executive Committee and Health and Wellness Committee. And we are very excited to have her impart her wisdom and knowledge and her how to get out of problems, tips and tricks to us. So Erin, welcome.
Thank you so much. I appreciate the invitation to speak today and the introduction. So without any further ado, let's start. So we're going to talk about how to avoid problems with the State Bar, which obviously most of those are going to be client complaints. There are certain things you're just not going to be able to control. The basic practice area will dictate the kind of volume of complaints that you're going to get. And here we are talking about immigration lawyers. But some examples where the area of practice really garners a substantial number of complaints are like collection lawyers, criminal defense lawyers, but immigration lawyers clearly get a significant number of complaints. Now, what you can control to avoid a legitimate bar complaint, you follow the golden rule. Basically, I don't see how you're going to be able to ever run afoul of any of the rules of professional conduct. And there's two prongs of the golden rule. The first one is you always put your client's interests ahead of your own. And recognizing that you're an officer of the court, you never make misrepresentations. If you live by the golden rule, there'll never be a legitimate bar complaint that can be lodged. Pretty much all of the rules of professional conduct in the State Bar Act are permutations of how lawyers put the interests of third parties or themselves above those of their client. And clearly, with respect to being overzealous, lawyers either bring claims that are unwarranted under the law or bleed into potential misrepresentations. Now, your risk management in determining how to avoid bar problems starts from even before you get the client. When are you going to turn down the client? And that's sometimes hard when you're a small firm or solo, and then you have someone that's ready to provide a retainer. But there are times that it just makes sense from the beginning to say no. Okay, when you have done that intake with the client, and this is, of course, after you've done the proper conflicts check. That's one of the ways attorneys get in trouble is if they don't run the proper conflicts check, which is kind of outside the scope of what we're going to talk about today. But assuming you've done the conflicts check and you're going to do the intake, if from that intake, you've determined that you can't meet the objectives of the client, then even if they could pay their retainer, it's probably someone that you need to pass along. Now, if your client in eliciting the story about what they're looking for a lawyer for has a history of multiple prior lawyers, that is a huge red flag, especially if they've made prior bar complaints against other lawyers. That means they're dealing with a very savvy, sophisticated type of client who knows how to use the system to game it for themselves. So you don't want to be the next, casualty in line of bar complaints. So really make sure during the intake you find out what other lawyers may have been handling the file before you. Now, if you're planning on taking the case, it's very important from the beginning to manage expectations. You have to ensure that the scope of services that you're going to provide are clearly defined and that you can provide a solution to the client from the very beginning. Now, also, some of the times you're going to be dealing with very unsophisticated clients that have maybe never hired a lawyer before. So it's especially important to make sure that the person realizes what you're going to do and what you're not going to do. And the scope of what you're not going to do is substantially more than the limited scope of your representation. You don't want it to be a situation where the client reasonably but mistakenly thinks, oh, you're my lawyer. And so you're going to be handling all a panoply of legal issues that you weren't hired to do. And if you leave it vague, the vagueness goes against the lawyer, clearly. Now, it's very important, especially in immigration cases, but truly in any kind of case, to identify who is the client. It's critical to know who are you actually representing at the outset. And this might sometimes be confusing because you might actually be hired by a company and they're hiring you and paying your fees. And in reality, it's for a petition for immigration for one of their employees. Depending on how you characterize the representation, you may have a dual representation and have joint clients and all of the risks that come with having joint clients, potential conflicts that might arise. Or you might have a situation where it's really the employer is just the third party payor, but your duties are always to the client. That matters because when you have your duties to your client, the duties of confidentiality and all of those other duties that run from the attorney-client relationship have to be protected, even if the purse strings are held by another party, either, let's say, a family member, parent, cousin, grandparent, or again, employer. So these kind of issues definitely come up when you have a potential joint client or even third-party payor situation. What happens if you're representing a family or a couple and now they're on the brink of divorce, well into your representation? You have to deal with the confidentiality issues when you have joint clients. The good news is that there is very good and already vetted language with respect to joint client representation that the State Bar put out in 2019 as part of the miscellaneous provisions for the with the fee agreements. So I really commend you to take a look at the fee agreements that have already been vetted through the COPRAC committee of the State Bar, and including the miscellaneous provisions with respect to joint client representation and third-party payor. Because if you actually are collecting the fees, not directly from your client, but from another family member or from an employer, you definitely have to have a separate third-party payor agreement that makes it clear that even though the duties are to the client, the duty to any refund would be going to the third-party payor. So again, you don't have to create that language on your own. I would, again, make sure I take a look at the miscellaneous provisions that the State Bar already has put out. And a lot of times you might have a client that doesn't speak your language, maybe Mandarin speaking, maybe Spanish speaking, and you're not Spanish speaking. You have to have practice, and maybe it's the family member that always calls on behalf of the client. If the client authorizes those communications, clearly, and I would make sure if they do, you have it in writing that they've allowed you to have those communications with the third party connected to the client rather than the client directly, have that documented, and again, make sure what is the scope of what you're allowed to talk to the third party about the person's case. Now, it's very important when you undertake representation that you formalize that representation to ensure that you receive proper notice from immigration. I'm sure most of everybody here is familiar with the Form G28 Notice of Entry of Appearance. Equally important is when you end a representation that you have ensured that you're no longer the attorney of record on anyone's case if they're no longer going to be your client. I can tell you horror stories of situations where lawyers, having signed a G28, left a firm, and now, months or even years later, they're being questioned about work on a case that they hadn't touched themselves, and that was left with the firm for months or years. So it's very important to formalize when you undertake a representation and also when you're ending a representation so that you get the proper notices and that the client remains protected. Now, the most prevalent type of complaint that comes into the State Bar is the lawyer won't return phone calls. It's a communication issue. It's lack of communication. And under Rule of Professional Conduct 1.4, you have really at least two different prongs of this duty to communicate. You have to respond to a reasonable status inquiry request from the client. And the reasonableness is obviously going to be based on the facts, because here we are lawyers. It's always based on the facts and circumstances. So if you have a situation that, let's say there's a very important immigration interview coming up in the next week, and you have a client that calls 2 or 3 times and gets no return calls leading up to that critical interview, that may be sufficient to not respond to reasonable inquiries of the client. If it's something that's less urgent, maybe missing 1 or 2 phone calls may pass muster. It's going to be based on the exigency and the circumstances of that particular communication. Now, here's an important prong that's especially true if you have very unsophisticated clients that haven't really been in the immigration system or even in the legal system in the United States at all. You have to reasonably consult with the client about the means by which to accomplish the client's objectives in their representation. What that means is the client is the one driving the bus. The client gets to decide if we're going left or we're going right. It's not for the professional to make the decision on which way to go. It's up for the professional to give the different options and then the risks and the rewards or the pros and cons of these options. And if you, again, if you have very unsophisticated clientele, it's going to take longer to make sure that you're communicating at the level where the client can meaningfully participate in the decision-making on their own case. You can't be speaking on just legalese terms in those kind of circumstances. Now, you also have the obligation under Business and Professions Code 6068M to respond to inquiries of the client and to keep the clients reasonably informed of significant developments in their matters. So it's two-pronged, both responding to reasonable inquiries and also to ensure that significant developments are communicated to the client. Now, how do you make sure, practically speaking, that this happens? You have to have a clear way to communicate with the client from the beginning of the representation. And this might be challenging if you have a client that isn't familiar with email and may not even have a smartphone. It's very important. And maybe you have a client that's very mobile and moves around a lot. So at the start of a long representation, and a lot of times immigration cases take months or years to complete, actually not months, you need to have a way to reach the client. So in your intake, I would suggest strongly that you get not just the client's current address and current email or phone number. You also have to probably make sure you find other family members. That way you might be able to reach out to the client through the family members. You don't want to lose track of your client. It also makes sense to periodically send out communications the client has to acknowledge, because later on, if you're facing a communication complaint, you want to show that the communication wasn't just one way, that the email or phone number that you were texting actually was the client. And if you are going to text with your client, which honestly 5 years ago, I would say never do that at all. But in today's world, it's probably impossible to avoid. Most attorneys I know, especially attorneys that are providing forward-facing to consumer type of work, they give out cell phone numbers and you get the cell phone number of the client. So texting may be one of the best ways to communicate with the client, but only if you properly document all your texts. Because if you've now converted your phone into the way that you're going to be communicating with clients and client matters, you need to have one of the commercially available systems, which there are many, including Google being one, which is, I think, is a free system, where you can actually document and capture all of the communications that are text, much more like you would in an email inbox. You can't, it would be dangerous, I would say, to rely on just that you keep your emails or your text messages in your phone. Because in today's world, you know, you change phones pretty regularly, every maybe 2 years, and you might get a bar complaint 5 years later. So it's a 5-year statute on general bar complaints, and there's many, many tolling provisions that make it even longer. So you need to maintain your client communications as part of the client file. It's not sufficient that they sit in your phone and you hope that you can produce them later. Now, you're entirely responsible for all of your staff interactions with your client. And that would be under Rule 5.3. That's your responsibilities to review and supervise your non-attorney lawyer, non-attorney assistants in your law firm. So make sure that when you're documenting all your communications with the client, that your staff also has a way to document all the communications with the client. Now, what a reasonable status inquiry is with respect to your obligation to communicate those, communicate and respond to those, again, as I've already said, is based on the facts and circumstances of the representation. My understanding is, and I've had many, many cases involving immigration lawyers, where the client pops up 2 years later, and there's been no activity in the intervening, 2 years on the client's case. So you really have to save yourself a lot of trouble, making sure you have a system where you can constantly document all the contacts with the client into the case notes right there on the online case management system. Now, with respect to significant developments, the best thing I could say is that, good news doesn't age well. I mean, bad news doesn't age well. So even if you're confident, whatever the judge said, it's going to be overturned later on, and you may be absolutely right, the fact that you got a bad preliminary or interim decision from the court should be communicated to the client. And pretty much anything that is a significant development that you're calling the client or you're having your staff call the client about also warrants some kind of written documentation, because that's the way it's going to, you're going to need that written documentation if later on you get a complaint from a client who says that you didn't let them know what happened on their case and that in absentia, they were, let's say, removed from the country. It's not enough to have had just that phone call. I really think to make sure you're protecting you and your law firm, you make sure that that's been documented within text or an email or some other way so that the client can't later on have a fuzzy memory or misunderstanding. And ordinarily, when there's a bad communication chain with the client, you get a lot of competency complaints. And this is especially true with respect to immigration, because as we're going to talk about, there are significant reasons why your former clients may want to bring a complaint so that they get an extra bite at the apple under the immigration court. So the basic competency rule is Rule 1.1. And generally speaking, a lawyer can't intentionally, recklessly, with gross negligence, or repeatedly fail to perform legal services with competence. And generally, Lozada complaints are competency type of complaints, basic ineffective assistance of counsel. And competency isn't just about learning and ability in an area. It also means that you have time and resources to undertake and complete the representation. So if you have a situation where it's a very busy immigration practice and clients kind of fall through the cracks because there's not a really solid calendaring system and notices from the immigration court are being missed, that would be a violation of Rule 1.1, even if you have a significantly sophisticated immigration practitioner. Now, With respect to competency, I would also caution that you document the course of action that you recommend to the client, and obviously whatever the client decides to take based on the smorgasbord of options that you provide the client. It's important to lay out the pros and cons of the possible courses of action so that the client can understand what the options are, and the client can make a decision on what's going to happen in his or her case. Now, it's also incredibly important to be careful about if you're going to be seeking relief, which may not be warranted for some alternative reason, such as to obtain a green card, then if that's going to be happening, it's very important that the client document that the client wants you to go forward. If there's no colorable basis at all to to seek a course of action, that itself may be incompetent, even if the client wants you to do it. But assuming you have some colorable basis to do something, but the real reason the client wants to do that is because it'll lengthen the time that they are allowed to stay in the United States when they otherwise would not be have that relief available, then it's important to document that that's why this is being done, and that the client has acceded to that course of action. Because later on, in the context of a Lozada complaint, you can guarantee the client's going to be saying that they had no idea that they weren't entitled to the relief you were seeking. So again, I cannot stress enough how important it is to document those kind of communications with the client. And you have to expect that there might be bar complaints, and there will probably be bar complaints lodged for another motive other than the fact that the person is upset with you. I can tell you, in the context of immigration law, many complaints come from unmotivated complaining witnesses. That means your former clients. They're not interested in getting discipline against a lawyer, which is not the same. That is not the case in many bar complaints. You have very highly motivated clients that either want money back or they feel they've been wronged and they really want the state bar to do something. In the context of these kind of immigration complaints, which are a significant number of the complaints coming against immigration lawyers, what's really going on is that the client wants to have alternate relief in immigration court. And in order to do that, they have to claim ineffective assistance of counsel, your counsel. And under Lozada, while it doesn't strictly require a bar complaint be lodged with the jurisdiction where that lawyer practices, basically it's important to have a Lozada type of complaint filed. And so the State Bar is very well aware that many of these kind of complaints are the result of this requirement to make a bar complaint under Lozada. Usually preliminary to the bar, to the Lozada complaint being filed, the new attorney will send out a letter accusing you, the immigration lawyer, of some type of misconduct. And don't ignore those letters. That letter is going to be Exhibit A to the State Bar complaint. So your response is going to be very important. It's going to be attached to your response to the bar complaint when it comes in. So take those letters very seriously and make sure you respond accurately. And honestly, this is a great opportunity to put your whole story together. I'm not saying story in the context of being fictitious or fictional. It's more like your comprehensive narrative explaining the circumstances surrounding your representation. So that's going to be the framework for your response to the State Bar's, upcoming complaint, a letter that you're going to get. So make sure that you properly respond. And if in fact you did something wrong, then this is the time to admit it and try to mitigate the problems for the client, obviously. Don't ignore it though, either way, even if you did nothing wrong. Now, I can't help but turn to trust account issues, especially in the advent of the CTAP program, or the Client Trust Account Protection Program, which was just adopted by the Board of Trustees last fall, and all of us now are documenting our trust accounts with respect to the certification when you're re-upping your license and paying your dues, which are due by February 1st. Now, your full certification under the CTAP program is not actually due until April 1st this year. They had an extra 2 months because some attorneys have obviously had to get themselves into compliance, and that's understood. So let's go over some of the basic trust accounting issues. And, this goes into how you collect fees, which may be helpful for you to avoid problems going forward. Now, in my experience, many immigration lawyers work on a flat fee basis, and there's absolutely nothing wrong with that. Since the adoption of the current rules of professional conduct, which was in November 2018, the only area where attorneys are still allowed to collect flat fees and deposit them into an operating account is in the area of flat fees. That's the only type of attorney's fees that can be deposited into an operating account, but they only can be used and deposited into an operating account under very limited circumstances. And that is when an attorney fully complies with Rule 1.15B. And we're going to look at that in just a moment. And basically, flat fees are only earned upon full performance. So up until an attorney has fully performed in a matter, are the entirety of the fees due for the flat fee. Prior to that, all the attorney is entitled to get is quantum merit. So it still makes sense when you're doing flat fee work to keep hours if you possibly can, because that helps you to avoid any problems establishing quantum merit later on. It's also a good idea in your engagement agreement, even if you're working on a flat fee basis and you have a special sign off under Rule 1.15B to establish your prevailing rate that the client becomes aware of. That's important for two reasons at least. One is if you do ancillary work, which is not covered by the scope of services of the agreement itself. I think the agreement should have a provision that any additional work that the client authorizes the attorney to perform or requests the attorney to perform will be done at this whatever prevailing rate. Also, if later on you have to establish quantum merit because you haven't completed the work, then having the prevailing rate in the engagement agreement at least gets rid of that one variable, which is your hourly rate. Then you still have to establish how much time you put into the case. Now, I've seen since the adoption of the current rules, how many lawyers have that do flat fee work, especially like in immigration, they've now broken it into phases. Instead of saying, let's say $5,000 for a complete immigration case, you would put instead saying up until the petition is filed or the petition is filed $1,500. And at the time of the preparing for the interview and going to the interview, another $1,500, whatever it is. Why do you want to do that? Here's why you want to do that. Because if you break the life of the immigration case into phases, then you earn all of the fees, the flat fee for each phase as it goes. You don't have to wait till the very end to see if you earned all $5,000. You've actually earned the $1,500 after the petition is filed. And then the next $1,500 when you've prepared the client for the interview, and then the interview happens. Whatever in your experience are the demarcation lines in the life of that case, that's what makes sense to break the representation into those phases. That way, you've fully earned each of the phases of the flat fee. And then you reduce the risk of having major issues with quantum merit at the end. Now, let's take a look more closely at Rule of Professional Conduct 1.15B. Basically, a flat fee paid in advance for legal services can be deposited into a trust account, provided not non-trust account, into an operating account. When one, the lawyer or law firm discloses in writing, one, that the client has the right under paragraph A that to require that the flat fee be deposited into a trust account until it's fully earned, and two, that the client is entitled to a refund of any amount of the flat fee that has not been earned in the event that the representation is terminated or the services have not been completed for whatever reason. And second, if the flat fee is over $1,000, this agreement to deposit the flat fee into an operating account and those disclosures required under B1 have to be set forth in writing. You don't have to come up with the language for 1.15B for your own engagement agreement. I again commend you to take a look at the under fee agreements on the State Bar's website. You can see under the miscellaneous provisions that COPRAC provided good language. So if you're going to be doing flat fee work and intend to put the money into an operating account, how you can have that paragraph into your engagement agreement. And my strong suggestion would be to have that paragraph separately signed off by the client so that it's bolded out. So it's very, very clear that the client gives separate consent to put those flat fees into an operating account. Now, if you do exclusively flat fee work and you intend to only be collecting advanced flat fees and keeping them in an operating account, do you even need a trust account? This is what I would say to that. If you ever take any deposit for costs, those costs always have to be into a trust account. And it's very difficult to open up a trust account on the fly. It takes usually for your financial institution several weeks to go through all of the permutations to open up a trust account. And there's, even though many lawyers are very concerned now under the CTAP program and the risk of random audits, there's no danger in having a trust account which has, just sufficient to cover bank charges, which would be maybe upwards of $250 to $500 of your own money to ensure there's no problems, in a trust account that you use very rarely. It still makes sense, even from an immigration lawyer who does 99% of their work on a flat fee basis and uses the operating account, to still have a trust account, because there are going to be situations that come up in the future where you're going to lose a lot of your ability to be nimble in the representation of a client if you don't have a trust account. Because under no circumstances can a lawyer ever hold third-party funds if they're not in a trust account. You may be, one of the ways to avoid having to collect advances for costs would be you can have the client directly use their own credit card or their own bank account and their own checks to pay for, let's say, filing fees with the immigration services or other kind of fees that might come up. And that might be a very good way to proceed in general. But the truth is, at some point, you may need to take advanced costs or even some hourly work. So it just makes sense to have a trust account open that you keep clear tabs on, rather than not have a trust account at all. Now, in order to avoid complaints, now, one of the things that is important about trust account violations is that under the way that the State Bar imposes discipline, and that would be under the standards for imposition of attorney sanctions for professional misconduct. These are basically the sentencing guidelines used by the State Bar Court in meting out discipline for violations. Trust account violations carry significant discipline, even when they don't include misappropriation of funds. There's no such thing as just a mere technical violation of trust account rules. They all carry potential actual suspension. So that's why it's imperative that if you're going to have a trust account, which I've already told you probably need if you're, unless you work for a government agency where you never handle any third-party funds ever. If you're going to be out there forward-facing to the public, it's probably a good idea to have a trust account, and it's imperative that you keep it, with parachute accuracy. Now, here are the obligations that you have that run from the fact that you're holding third-party money and you put it into your trust account, not just client money. You have a duty to promptly notify the client and any lien holders or any other third parties who may have claim on those entrusted funds that you've deposited. You have to promptly notify. And under the most current iteration of Rule 1.15, which just was adopted at the beginning of this year, that's 14 days. So if there's any reason that you're taking in monies like a settlement or anything like that, which generally speaking would not happen in an immigration case, you have to notify receipt of those funds within 14 days. You also have to promptly pay out entrusted funds. And the presumption under rule of 1.15 D7 about promptly paying out, promptly is a rebuttable presumption to be 45 days, which is a month and a half. So unless you can establish that the money is in dispute for some reason, it has to be promptly paid out, and that's about a month and a half, which can be challenging depending on how closely you're watching your trust account and making sure everything is accurate. With respect to notifying receipt of funds, I honestly believe it's important if you have a basic case management system, which also tracks monies in and out of your trust account, to do an invoice to show the receipt of trust funds or the receipt of the operating. If you put it into your operating account because it's under rule 1.15B, still make sure you issue the invoice to show that they paid the flat fee of $5,000 or whatever it is they paid. It's not, if worst comes to worst, at least the handwritten receipt, because I think that's going to be what you're going to need to show full compliance with 1.15 D1. You can't just be on later on hoping that, periodically we're going to send out statements, and those statements are, maybe a year or so apart. Now, you also have a duty under rule of 1.15 D4 to provide an accounting for all monies that you've received. And this rule references entrusted funds, but this would also mean if you had the client consent to deposit the advanced fee, flat fee into an operating account, you would still have the duty to account. You also have a duty to preserve all records of distributions for at least 5 years from the last disbursement. And that's rule of 1.15 D5. I didn't put this on the list, but now especially true since we're in now random audits have been authorized, and they probably will start right after April. You have a duty to comply with a reasonable audit request from the State Bar. Now, let's turn to another area that attorneys get in trouble with and may cause bar complaints, and that is your duties at termination. So to avoid valid bar complaints, it's important that you take the proper steps to disengage and terminate your representation when warranted. Now, if it's still an ongoing case, you have to take steps to formally withdraw. If you're before a tribunal, you would have to get permission from the tribunal, which is in the nature of a motion to be relieved as counsel with proper notice to the client in order to withdraw. But if you're going to bring one of those motions to withdraw or motion to be relieved after giving notice to the client and trying to get the client to sign a substitution, if they won't do so, you have to be very careful that in the context of that motion that you protect all client confidences, which you have an obligation to protect under Business and Professions Code 6068E. And you also have to take steps to avoid reasonably foreseeable prejudice to the client all the way up until you're relieved. So you can't just stop work on a client if there's been a breakdown of the relationship. You have to work on the client's case and keep at least the status quo until your motion to be relieved has been granted. I actually have seen several cases where attorneys, having had a falling out in the firm where they were at, still remained attorney of record because they never, again, properly had another G28 for substituting in another attorney, and they didn't bring a motion to withdraw as counsel and give client notice. And so later on, months down the road, or even years down the road, the attorney can get an order to show cause from the court about what's going on in the client's case, even though the attorney hasn't been at the firm for months or years. I've seen that multiple times. And it's always going to be against the attorney if you don't take proper steps to disengage from the representation. Now, at the time a case, you're no longer going to be working on a case, either because you've completed the representation and there's no more work to be done, the client's case is over, or midstream the client decides to get a new attorney, or even just to represent themselves, the client is entitled to their complete file. And it's potentially an open question about whether or not you can give them, do you have to give them just a scanned copy if you keep electronic files, or do you have to give them the Word or Word Perfect version, depending on what software you use? Honestly, if you're going to be, I would not want to be the cutting edge question, the case that the State Bar brings on that issue. If the client asks for the Word versions of documents, it's probably a good idea to give them to the client. Why? Because the client may need, if it's especially an ongoing case, the client may need those to complete the representation and not have to key in, substantial amounts of text. Don't make it difficult for the client, even if they've made it difficult for you. The client file includes all, everything that the attorney has on the file, meaning if you have depositions, and even if the client didn't pay for the depositions, and you're the one that has to pay for the depositions because you ordered the transcript for the client and now they're stiffing you, that's still part of the file. Expert reports, similarly, even if they didn't pay for it, they're entitled to it. It's part of their file. You cannot withhold the file in order to secure fees that are owed. That's itself misconduct. And in today's world, most attorneys are working on at least mostly electronic files. So it's very important from the outset of the engagement that you put in a provision in your engagement agreement about how you keep your files, either hard copy or electronic. And again, I strongly suggest you take a look at the proposed language in the engagement agreements that were issued by the State Bar as templates, because that way it has the language about that you're going to keep your files in the cloud, and that there's a risk and benefit to that, meaning the benefit is that it keeps things ever available. And it probably streamlines the representation process, makes it less expensive for the client. But the risks are, if something's in the cloud, there's always a risk that it can be hacked. And if you are using electronic files and you are storing your files in the cloud, it's very important that you use, at minimum, the state of the art to keep the files encrypted and keep them safe. So if you keep them in, let's say, OneDrive, or you keep them in Dropbox, whatever it is, make sure that that has all of the encryption and protections that are necessary to protect highly sensitive client information, because attorneys' files for clients usually contain highly confidential information that you have to protect under Business and Professions Codes 6068E. So if you don't use proper file maintenance for your online files, that itself may be misconduct. So even if you're yourself not some kind of cybersecurity expert, that's not what's necessary. What you have to do is at least have good IT for your firm, and make sure that you're using commercially available state-of-the-art Clio, whatever case management system you have, to keep the files safe on behalf of your client, obviously. Now, under Business and Professions Code section 6068E, you have a duty upon termination, subject to if there's a protective order or non-disclosure agreement or something, to release the file all the client's materials and property. And that's correspondence, pleadings, depositions, expert reports, and other writings, physical evidence, etc., whether or not they're whatever form you keep them on, and whether or not the client has paid for them or not, as I said. So it's very, very clear that the file belongs entirely to the client. And remember, if you decide to start engaging in client communications by text, you're going to have to somehow be able to produce those as part of the client file later on if the client asks for them. So it's incredibly important that you have a proper system to document communications with your client. Now, if you are approached by successor counsel, your only recourse is to sign a release the file, and sign the substitution. There's no way to wrangle with the client, with the client or the new counsel about who's going to represent the client, because at that point, if you continue to try to communicate with the client, you'll be communicating with the represented party, which is itself another type of misconduct. All right, so now I think we got through most of the material. So I want to be able to take a look and see if we have any questions that I can answer. And I also know that there were some hypotheticals that I was going to entertain toward the end here. So again, if you have any questions about trust accounting, the changes, or any of the other things we talked about, you can go ahead and put that in the Q&A. In the meantime, I think we have a couple hypotheticals.
This is one of the panelists, but Erin, thank you for the very informative seminar. I have a little question on behalf of the immigration lawyers. So let's say immigration lawyer A collects the flat fee, deposit the IOTA account. Now there's a difference between the IOTA account and the client trust account. Now this attorney A only deposits his or her future attorney fee that's more than $10,000 for about 6 to 8 months in the IOTA account, but IOTA account only allows for a temporary small amount. So how do you handle that kind of situation? Thank you.
Oh no, I'm glad you asked that. I've gotten a lot of calls since like maybe November into all the way through December, because everyone's like getting ready to do the certification there, and there's a lot of confusion about when you can use an IOLTA, which is interest on lawyer's trust account, and when a separate trust account is required. Now, an IOLTA, which is the interest on lawyer's trust accounting, that is a general trust account, as opposed to a segregated trust account. And a segregated trust account is when you are going to be receiving either more than a de minimis amount of money, or it's going to be held for more than a short amount of time. The classic use of an IOLTA trust account, general trust account, same, they're just synonymous terms, is, let's say in a personal injury practice, you get a $500,000 check, clearly not a de minimis amount of money, but the idea is as soon as the $500,000 check is deposited and it clears the account, that money is going to be paid out to the client. The attorney's going to take their fees, and then all the lien holders are going to get theirs. So it's going to be paid all the way out to zero, shortly after receipt of the check. Now, what is an attorney that does hourly work? Let's say myself, I do hourly work 90% of my work. If I receive an advance deposit to do work, let's say $8,000 to do a state bar proceeding, that money is going to be deposited into my IOLTA, or my general trust account. The reason why is that it belongs prospectively to me, because the client paid it to me expecting that I'm going to earn it as I do work. And over the next course of weeks and months, even hopefully not years, months, if it's state bar proceeding, I'm going to earn that money as long as within that time of the case. So advanced deposits for attorney's fees are appropriately put into a general trust account, because you're going to be earning them as you go, right? You're going to be probably working on the case maybe this week, maybe this month, maybe next month. So even if they give you a $10,000 deposit for, let's say, their immigration case, totally fine to put that into a general trust account or an IOLTA account. When do you have to use a separate segregated trust account? That is when it's going to be not a de minimis or small amount of money, and it's not going to be a short amount of time. The classic situation for that is if you're doing, let's say, a family law practice, or even I've seen it in immigration, where you're going to take the large check, which is going to be deposited to be, let's say, invest in the company once someone's visa is approved, or in a family law case, they sell the marital home and there's no marital settlement agreement yet. So where are we going to put the proceeds? That should not be an IOLTA account or a general trust account, because it's not a small amount of money, and you have no idea like when that visa is going to be approved, or when the family law case is going to settle and everyone has resolved the marital settlement property issues. That's when you go into the bank and you open up a separate trust account with that, proceeds of the escrow account, escrow check. And it's going to be literally, Erin Joyce trust account for the benefit of client A and B, not client B, but the other side of the case. So that's what the individual trust account is, when it's individualized money that's going to be there for quite a while, could be months or years before a family law case settles, and you have no idea when the visa is going to issue, something like that. So that's when you have to do a separate trust account. You can't commingle that money into your general or IOLTA trust account, because again, it's not a small amount, and it's not going to be there just an ephemeral short amount of time. But even a $10,000 check for attorney's fees is going to be quickly moving, or the idea is you're going to be earning it as you go. So that's totally appropriate. Hourly deposits are appropriately put into a general or IOLTA trust account. And you can, an attorney, depending on your practice, you may have multiple trust accounts. And with the State Bar, you have to register all of them. So your IOLTA account, or your general trust account, and any individualized trust accounts you have on behalf of any particular clients or that matters.
The next question, of course, you say the minimal amount and minimal time. Do you have rule of thumb, like what is the minimum amount and what the minimum amount of time? I don't practice family law. Maybe it's useful for the personal injury lawyer and family lawyers, or the lawyers who practice, let's say, investment immigration or EB1, EB2 cases.
Again, if you're taking advanced, any kind of attorney's fees that you take other than a straight flat fee, where you have the sign off, special sign off under 1.15B, have to be deposited into a general trust account. They do. It doesn't, even if it's a tiny little, let's imagine you take $2,000 to start someone's case. If it, but it's hourly. If it's an hourly case, even if it's $2,000, you have to put it into a trust. You can never take advanced fees and without putting it into a trust account, except for in that circumstance of the flat fee with full compliance with the rule 1.15B. And in my experience, a lot of immigration lawyers do flat fee, a lot of criminal lawyers do flat fee. Some types of let's say like some kind of patent and trademark prosecution can also be flat fee. I've seen those kind of agreements. That's totally fine. There's nothing wrong with using an operating account, and if you have full compliance with 1.15B. But other than those, limited type of circumstances, all other advanced fees must be put into a trust account. Now, I have a couple more questions here in our Q&A, so let me make sure I hit these. What if a client owes you money for work performed? Can you request for them to pay you before you give them the file? This is the thing, you cannot hold the file hostage for payment. That's usually what happens. There's been a breakdown of the relationship. There's still work to be done on a case, and you're like, I'm not doing any more work because you haven't paid me. Well, if they have to go get a new attorney, or they're going to ask for their file, even if they have stiffed you, you have to give them the file. And it's a serious violation to withhold the file for payment. That doesn't mean you're letting go that they owe you money. You still pursue them, whatever recourse you have to get the outstanding fees. But one of the approaches isn't to hold the file back, because you have to make sure that the file is delivered. And if you're going to be delivering the file, especially to a now unhappy client, and you have even the slightest whiff of a potential malpractice or fee dispute brewing, the best approach is to keep a copy of the file for yourself, obviously. And that's on your dime, generally speaking. If you have an electronic file, it's obviously not hard. You already have a copy. But if you have to scan the file, you do have, when it's promptly, turn over the file, you have a sufficient time to make the copies if you need them. But if you have an inkling that it's starting to be a problem and you have a client that's going to sue you or make a bar complaint against you, you want to keep a copy of the file. But they are entitled to the original. So if you still have hard copy files, they're entitled to the original, and you keep a copy. Now, if you still have hard copy files, let's say, and they want an electronic copy of the file, well, too bad. They get the file as you kept the file. You don't have to scan the whole file for them. But if you have a very uncooperative client that you think that might sue you, you may want to make that scanned copy of the file just for yourself, because you're going to need it for defensive purposes. And yes, you want to absolutely make sure that if you're going to turn over the file, that you document how that file is being turned over. That if they come to your office to pick it up, that they sign a receipt for the file. Or if you're going to send it, don't send it in regular mail, send it with proof of delivery, overnight mail or some other way to have proof of delivery, because you don't want to have them later say, I never got the file. Now, if you offer for the client to pick them up, but they would prefer you to FedEx it, can you request that they pay the FedEx fee? You can always request, it never hurts, but okay, I think this is one of the facts and circumstances is going to matter. If you've always met with the client in your office and they live locally, and they want you to incur the 60 or $100 to do the FedEx, you can tell them the file is available in, again, not just tell them, document, the file is available for pickup, between 9 and 5, blank date, let me know when. We're not going to incur the cost of overnighting it. But then you're going to get into a tussle with them. And that probably would be okay, where you decline to incur the cost of the FedEx based on those facts. But again, do you really want to get into a kind of battle and have the State Bar have to mitigate that or litigate that? I wouldn't. It's not worth it to you. Now, if it's conversely, you've only dealt with this client over, email, and you've never met in person, and they live in Northern California, then saying, oh, the file is available for pickup here in, Pasadena, probably not going to fly. So it's going to be based on the facts and circumstances. Now, what constitutes the file? When substituted out of the case, are you required to turn over your personal notes with the file? Now, if you keep the personal notes as part of your file, probably yes. But generally speaking, that kind of work product, okay, there's no work product protection against your client per se. But if you have the custom of practice that you throw away drafts, and that after deposition, you take some notes and then you do a file memo, and that becomes part of the file. Then as long as you have a custom and practice of not keeping those things as part of the file, then obviously you can't be forced to produce that which you don't regularly keep in the file. So I myself don't keep drafts. I don't store them. That's part of the way I do my files. I think that's safer, but depends on your type of practice. In my type of practice, it's not helpful at all to keep drafts. But there may be, if you're doing contract negotiations, I think that not keeping the drafts would be probably malpractice. So based on your type of practice, I would say, I don't know why you would have to, if you've already made a file memo based on an interview or this or that, I don't know why if your handwritten chicken scratch notes should have to be part of the file. That's how I would answer that question. Now, are there any other questions I can answer before we finish up here in the last 3 minutes? Oh, wait.
I had a question actually.
Sure.
About the dual representation, because most of the time, immigration attorneys are representing like an actor, the beneficiary typically. But then when you sign the G28, you sign the G28 on behalf of the petitioner. You can't have both. You can't sign a G28 for both parties. So even though your agreement is then with the beneficiary of this particular petition, technically to the government, the petitioner is your client. Even if the beneficiary, in most circumstances, the beneficiary is paying for their own fees and the employer is not paying any fees. So in that case, should you include like a paragraph saying, in this representation, I will be also representing your employer as part of the process, or how would you handle that?
Oh, absolutely. Yeah, there's nothing wrong with having joint representation as long as there's full compliance and you get the waiver of any potential conflict. And you can see there's at minimum a potential conflict in that situation where you have the petitioner and the beneficiary. Because what happens if there's been some falling out and now the beneficiary is no longer going to be working with that employer? I mean, obviously it's going to change the course of the representation, and you have duties to both. It may be a situation where there's mandatory withdrawal because you can't reconcile the conflict there. But at the outset, it's important to have the joint client waiver information,
So just
paragraph language in your engagement agreement. That's what I would do.
Overly put stuff in your engagement.
It never hurts to have that if there's a potential. There, I would say for sure it's a joint representation because you're representing on a government document that you're representing the petitioner, and then you have an engagement agreement with the beneficiary. Right. So I'm saying both.
Okay, good to know.
If you have any questions that pop up later, please look me up in Pasadena. It's Erin at Erin Joyce Law. I'm happy to answer questions that you may want to email me if something pops up after this. But again, I appreciate the opportunity to present to you today, and wish everyone a happy new year into our 2023.
Oh, somebody just popped up. Where can I read about the new banking rules? You know
Oh.
that off the top of your head?
I can just tell you, if you go on to the State Bar website, again, they have a whole FAX section, FAX section about the new client trust account protection program. And they have links to the new rules themselves, which have just went into effect of January 1st. And they have a provisional like pre-test that you can take for the certification. So you don't have to see it for the first time as you're trying to do your pay your bar dues or your bar licensing fees. I suggest you take a look at all those things, and you have to actually, because one of the things you're certifying is that you familiarize yourself with the new rules. So you have to have read all those before you do your certification. So it'll probably take you an afternoon to go through all of those and do the practice 12 questions. And honestly, make sure that your trust account is in full order before you do that certification, because you're certifying as of the time that you submit that certification under penalty of perjury to the State Bar that you're in full compliance. It's a kind of waffly language, but from myself and from other practitioners in this area, looking at that language, it's not like you're certifying that for the entirety of the reporting period, which reaches back to last January, that you've been in compliance, that as of the time that you do the certification, you're in compliance. And it's critically important that you do that, because if you are in that small cohort of people that are being audited and you actually are not in compliance, it won't be prosecuted solely for the trust account violations that you may have engaged in, which are serious on their own. It'll also be prosecuted as moral turpitude, misrepresentation to the State Bar. And that itself, they're looking at very serious discipline. So don't take this lightly at all, the CTAP program.
Oh, yikes.
BHBA also had a CLE specifically on the new trust accounting rules last week, and I don't know how quickly Kathleen could put a link in there, but if you're looking for more resources in addition to what's on the State Bar website, the CLE was very helpful last week also. So with that, I know you have a hard stop. You've got a court appointment this afternoon, Erin. So thank you very much for your time and for all of your expertise. We really appreciate that you were able to come out to speak to us today. Thank you.
Thank you. Bye-bye. Thanks a lot.
Thank you.